there's certain things that are within your control, right? You're not going to be able to sit down and write like this brilliant, brief that, would make one of these partners say like, man, I wish I could have written that. The stuff that's within your control is stuff like the way you cite authority in briefs, right? There's a very like the blue book is what lawyers use, and it's very like step by step. Here's how you cite a case. Here's how you cite a statute. Here's how you cite a federal regulation. Here's how you cite, a publication by the Congressional Research Service on a particular topic. Those should be perfect because you can make those perfect. On the other hand, legal writing is something that takes time to develop. So anything that you can make perfect at an early stage should be perfect. There's really no reason that it shouldn't be. So that was one of the things that I took to heart, and I tell other junior associates as they come in. The number one most important thing out there for a young the junior associate, in my experience, is especially if you're doing legal research, Google Scholar. So when you're in law school, you have like a sort of free subscription, Westlaw, Lexis, and you can do all these very complex searches and come up with all these different cases and statutes as a result of that. But Google Scholar is basically the same thing, and it's free. And honestly, I found cases sometimes when I'm doing legal research on Google Scholar that aren't even in Westlaw, which you pay a lot of money for. So that to me is the number one resource that I didn't know about coming in, that I use it on a daily basis probably. The one thing I'll note too about that, if sort of like a little bit more detail, is a lot of times with Westlaw and LexisNexis, researchers will use what's called terms and connectors, which you'll say like, I want the word, I want the term breach of contract within 5 of like, construction defect or something like that. That's the one thing that Google Scholar does not allow you to do. But what you will quickly realize is that is the most overrated function ever. I never seem to get a good result using those terms and connectors. And it's obviously like I'm not a pro at using terms and connectors, but I will get, legal research assistants from Westlaw on the phone, help them, put together one of these searches, and I still don't get anything. So it's highly overrated. You use Google Scholar, you put in your terms without any of these terms and connectors, and then it'll spit out a whole bunch of results. You read the little brief passage where your search results are found, and it's a little tedious, but you go through and you see which ones could be relevant. And you just go through that, and that is the best tool, especially for like if you're in a big firm or you're doing legal research. What else more broadly, Google generally, right? This, like, whenever you're faced with like an issue that you've never dealt with before, you want to have background on it before, because usually the partner, whoever you're getting this assignment from, will give you like very, very specific questions. And what they really, really are asking you for is like, find me a case that says exactly this under these exact facts. And that's usually you're not going to find that. And in order to find that, you sort of need to guide your research down the right path. So do a Google search on any particular Tariff Act of 1930, right? You'll find Wikipedia articles. You'll find articles written by other law firms. You'll find news alerts regarding recent cases that may be applicable to what you're looking at. That's usually the starting point. And then once you're able to narrow your search, then you can go to other tools. But Google search, especially when you've never done something before, tremendously useful. Let's see. The other tool, treatises, right? So for instance, procedural issues, you have the Rutter Guide in California, which is great. My only word of caution on the Rutter Guide is it will give you sort of what the law is and not how it's always applied. You know what I mean? So I'll give you an example. Like the Rutter Guide in discovery will tell you that if you fail to serve objections to some type of discovery request in a timely fashion, you've waived all objections, including attorney-client privilege. There's no way a court is actually going to say, all right, yeah, sorry, man, you blew the deadline by a day. Now you got to produce all your privileged communications with your client. They're going to grant you some type of relief from that. Another great resource is called, there's a legal author by the name of Brian Garner. He's written a whole bunch of books, but he writes about legal writing and good legal writing and the hallmarks of that and how you can sort of improve your legal writing. The best book, the one that a number of associates at our firm have and I've read and I reread whenever I get the chances, it's called The Winning Brief. and it sort of tells you here's what a good brief looks like. And it's a simple topic, but it's pretty complicated. It breaks down into like 100 different chapters. They're all pretty short. They're all very digestible, and most importantly, they're all written in the way that he wants you to write. So just by reading this, you're sort of absorbing the manner in which like what good legal writing looks like. And it's not complicated. I mean, it's straightforward, short sentences, simple to the point. Don't use jargon. The tips like that, and obviously I can't do it justice sitting here explaining it to you, but it's an excellent book, and I would highly recommend that as well.